Now, John, what are the common reasons lead to the CBP denying admission? You touched this a little bit on my intro opening SOS question, but then if you can, go a little deeper, dive into this. What are the common reasons lead to a CBP denying admission at U.S. ports of entry, and how does this relate to fraud findings, including the F1 OPTs and H1B visas, and how does the inadmissibility process at the port of entry differ from other immigration proceedings while they're in the country? And what rights do individuals have during this process? You touched this a little bit. I would like to retouch this a little more detailed info, please. Thank you.
Sure. So the unfortunate reality is that before you even hit the port of entry, you've been flagged in the system, and USCIS DHS has put a fraud finding on your record in many of these situations. And they've done that, not from overseas, not at the port of entry. They've done that here in the U.S. And legally, they're required to, when they're making a decision in the U.S., to give the interested party, the person that's impacted, notice and an opportunity to respond. Because so many of these fraud findings that they're doing are incredibly shaky and indefensible in court, they're avoiding going through the legal process that they're required to do and doing the fraud findings in secret and waiting for you to leave the country and try and come back in only to find out that there's a problem. So that happens in a number of different ways. One is they can just wait for you to go on vacation and then hit you when you come back in. The other is the change of status denial. If you're going from F1 to H1, your status gets denied, but your petition gets approved, that's a pretty strong indicator that you got a fraud finding. So if the USCIS has put a fraud finding in the system against you, really the consulate should not be stamping your visa, and the port of entry won't allow you into the US. At the port of entry, they'll do one of two things. They'll give you a notice under 212A7, which is you don't have the proper documentations to enter the US. Or they could give you a 212A6, which is a fraud finding. The reality is, in almost all of these cases, that A7 finding is not technically accurate, because when you showed up at the port of entry, you had a legal visa, you had legal authorization to come into the US. They revoked it because of a fraud finding, and now you don't have papers. So the thing that they kind of dance around with that is that an A7 finding has a 5-year ban to re-entry into the US. An A6 has a lifetime ban. So people are thinking that they've got, this 5-year ban, when in fact it's a lifetime ban.
Okay.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.